record the. Okay. Kindly note that I'll be recording this session hereafter. Good morning, Your Ladyship and learned councils. Welcome to the 6th TGA Virtual Moot Court Competition. My name is Snigdha and I'll be acting as the court master for this session. It is my distinct honor to welcome our esteemed judge, Advocate Anjani Nishtala, for this round. Anjani Nishtala ma'am is an advocate practicing in the High Court of the state of Telangana with experience in constitutional, criminal, and civil matters. Having graduated from Pendakanti Law College, Hyderabad in 2022, she has been practicing exclusively in the sphere of litigation. After graduation, she began her career in preventive detention matters and owed to her passion for human rights law. She has also gained experience in appearing for the state through her attachment with the government pleader for MAUD, Agriculture and Cooperation. We thank you for your valuable time and efforts in adjudicating this session. Before we proceed, I request all the participants to ensure that they have a stable internet connection. Please keep your cameras turned down throughout the proceedings. If you experience any technical glitches or connectivity issues, strictly communicate this via the chat box immediately. In the event of a disconnection due to bad internet connectivity, a maximum extension of 5 minutes will be granted to the affected speaker to reconnect. With the permission of the judge, may I please proceed to outline the rules of the competition, ma'am?
Yes, proceed.
Thank you. The structure of the proceedings will be as follows. Counsel 1 and Counsel 2 for the appellant will present the case, followed by Counsel 1 and Counsel 2 for the respondent. Each speaker is allotted a total of 15 minutes. Any extension beyond this time is subject solely to the discretion of the judge. I humbly request the judge not to grant any extension of time due to a fixed schedule. As court master, I will be strictly monitoring the watch. Screen sharing of judgments or documents is permitted only with prior permission from the judge. The court is in session now. Thank you, ma'am.
Greetings, Your Ladyship.
I'm unable to see.
Greetings, Your Ladyship.
Yes,
Am I audible?
yes, you are now.
Much obliged, Your Ladyship. Your Ladyship, greetings, Your Ladyship.
Good morning. Please proceed with your arguments.
Yes, Your Ladyship. Your Ladyship, the counsel seeks permission to address the bench as Your Lordship.
Granted.
Much obliged, Your Lordship. Your Lordship, this is the counsel appearing on behalf of the appellant in the case of ABC Bank versus XYZ Private Limited. This present civil appeal has been filed as per the provisions of Section 62 of IBC 2016. If Your Lordship permits, the counsel may move on to the facts of the case. Your
Go
Lordship.
ahead.
Yes, Your Lordship. Your Lordship, in 2013, the corporate debtor was incorporated under the Companies Act 2013 and obtained a loan from ABC Bank of Rs 500 crores. In 2014, the corporate debtor made irregular payments, and after the 90-day RBI period, the loan account was declared as non-performing asset on 1/4/2014. After which, starting from 2014 to 2022, corporate debtor repeatedly sought for one-time settlement. Although one such one-time settlement was approved on 1/2/2020, it failed to comply within the given period, leading to which the bank cancelled the OTS. After which, in 2020, ABC Bank filed an application under Section 7 of IBC, citing 1/5/2020 as the default date, but it was rejected under Section 10 capital A. Again, in 2024, the bank filed an application under Section 7 using the NPA date as default. It was dismissed as time barred, leading ABC Bank to file an appeal under Section 62 of IBC before this Honorable Supreme Court. If Your Lordship is satisfied with the facts of the case, the counsel may move to the issues in hand, Your Lordship.
Okay, go ahead.
Much obliged, Your Lordship. Your Lordship, there are 4 issues in hand revolving around the subject matter, namely, Firstly, whether second application under Section 7 is allowed or not. Secondly, whether mentioning of default date is mandatory. Thirdly, whether default date can be changed based on facts and circumstances or not. Whether
Hmm.
an application can be admitted despite an error. Your Lordship, the first two issues will be dealt by the first counsel in 15 minutes, and the other two issues will be dealt by my co counsel. Your
Hmm.
Lordship, the counsel seeks permission to screen share the precedents by the researcher whenever required, Your Lordship.
Allowed.
Your Lordship, the council may move on. Your Lordship, the first issue deals with whether or not a second application under Section 7 of IBC is barred by law. It
Hmm.
is most humbly submitted that the second application under Section 7 of IBC is not barred by law. This will be substantiated under three heads, Your Lordship. Firstly, Section 10 capital A is a temporary moratorium. Secondly, non applicability of res judicata. Thirdly, no limitation bar. Moving on to my first limb of my argument, that is Section 10 capital A is a temporary moratorium and not a permanent bar. Your Lordship, the main essence and purpose of inserting Section 10 capital
Hmm.
A is to prevent the companies from
Hmm.
CIRP, which genuinely faced a loss due to the pandemic situation, unlike a permanent
Hmm.
injunction, Your Lordship. And it is pertinent to note that it does not extinguish the right to file a new application with defaults that arose before the COVID cutoff date once the moratorium period gets lapsed, as clearly stated in the case of Ramesh Kaimal versus Siemens Gamesa Renewable
Hmm.
Power. Your Lordship, the prohibition on Section 7 applications applies only where the default occurred on or after 25th March 2020.
Hmm.
In the Dharam K. Patel and another versus Indian Bank and others 2025 case, Your Lordship, the Council would like to bring attention to this recent judgment which is being displayed by the researcher, where the court observed in para
Where
27
is
that
this judgment from?
if the default began even before that date, the statutory bar does not apply,
Council,
even
is
if
this a Supreme Court judgment or a state government judgment?
Your Lordship, this judgment has been taken from the official website, and this judgment is the case title is Dharamshi K. Patel and
Um,
Your Lordship, the council shall proceed with the arguments, Your Lordship.
I'm sorry, can you give me the citation again? I'm unable to tell whether it is a Supreme Court judgment or if it is a state judgment.
Your Lordship, it is the citation is 2025 MHC 208, Your Lordship.
MHC 208.
Yes, Your Lordship.
So that must be a Maharashtra High Court.
Yes, Your Lordship.
How can I uh,
Your Lordship, it is Madras High Court, Your Lordship.
okay, go ahead with your extraction of the point.
Much obliged, Your Lordship. Your Lordship, in this case, the para 27 states that if the default began even before that date, the statutory bar does not apply, even if overdue payments continued into or beyond the moratorium. Your Lordship, in the very present case, the financial creditor clearly classified the corporate debtor's loan account as non-performing asset as on 1/4/2014, indicating the failure to diligently repay the amount even long before the COVID-19 was known to exist. Further, the OTS requested by XYZ Private Limited on 1st January of 2020 clearly relates back to the repayment of the debt amount which has been accumulated since 2014, and the same was approved by the bank on 1st February of 2020, stating that the entire debt amount as agreed has to be paid on or before 31st March 2020. And it is pertinent to note that COVID-19 caused huge impact in the economy starting from the last week of March 2020, Your Lordship. Being this stated, the Council would like to highlight the point that the determined XYZ Private Limited, which constantly requested for OTS, was unable to repay the amount only because that there existed COVID-19 impact on the last 6 days of the month of March, which is clearly an absurd defense under the veil of Section 10 capital A, Your Lordship. Therefore, the statutory bar under Section 10 capital A does not become a bar for the second application under Section 7 of IBC. Moving on to the second contention, that is non-applicability of res judicata. Your Lordship, it is a well-established fact that the principle of res judicata can be invoked under Section 11 of CPC only when there exist same parties, same cause of action, and when the matter is settled based on merits. In the present factual matrix, the second application does not involve the same cause of action, Your Lordship, as by agreeing to OTS requested by XYZ Private Limited, the amount to be paid gets lessened as in comparison to the original outstanding amount that is to be paid as per the original debt liability. Your Lordship, further, a dismissal on technical or statutory grounds, such as limitation or a statutory moratorium, does not satisfy the requirement of a matter being heard and finally decided under Section 11 of CPC, as it does not involve the adjudication on the merits. In R.M. Sundaram versus Kayoranasamy Amman Temple case, the Supreme Court held that without any inquiry on the substance, the principle of res judicata cannot be invoked. Your Lordship, in the present factual matrix, the first application was dismissed without any adjudication on the validity of XYZ's debt or default. Your Lordship, moving on to my last contention, that is the no limitation bar. Your Lordship, as per Section 238 capital A of IBC, Limitation Act comes into play. But there is an exception in its application in certain cases. In the case of Dena Bank versus Shivakumar Reddy and another, para 142 of the judgment as displayed emphasized that Section 18 is an application under Section 7 of IBC would not be barred by limitation on the ground that it had been filed beyond a period of 3 years from the date of declaration of the loan account of the corporate debtor as non-performing asset if there were an acknowledgement of the debt by the corporate debtor before expiry of the period of limitation of 3 years, in which case the period of limitation would get extended by further period of 3 years. Your Lordship, in the present case, letters and the one-time settlement proposals sent by the corporate debtor from the year 2014 till 2022 acknowledges the liability to repay the debt to the financial creditor. Your Lordship, therefore, the Council most humbly submits that, considering the above mentioned points, the second application is not barred by law, Your Lordship. If Your Lordship is satisfied with the first issue, may I move on to the second issue in hand, Your Lordship?
Can you just go over the point again about how it doesn't attract the section 11 you were just mentioning, no, of the CPC? Can you tell me how that you want to apply here?
Much obliged, Your
That
Lordship.
aspect
Your
of section
Lordship,
11.
it is well established. Yes, Your Lordship. Yes, Your Lordship, in order to invoke Section 11 of CPC, that is the principle of res judicata, there are certain essentials which has to be complied with, Your Lordship. Firstly, there must be same parties to the proceeding, and there must be same cause of action, and it must be settled based on merits, Your Lordship. That is that is challenging the substantial question of law. Your Lordship, in the present case, the second application does not involve the same cause of action as the earlier application, that is the first application, Your Lordship, because the ABC Bank has agreed to the OTS requested by XYZ Private Limited. The amount to be paid gets lessened as in comparison to the original outstanding amount that is to be paid as per the original debt liability, Your Lordship. Because in general, the one-time settlement is an agreement between the debtor and the creditor, wherein they come to a compromised set to be paid, Your Lord. to be paid, your lordship. Therefore, the amount which is to be paid as per the OTS is lessened in comparison to the original outstanding amount, your lordship. Therefore, there is no same cause of action or amount in debt to be paid by the corporate debtor towards the financial creditor. Therefore, there is no same cause of action in both the applications, your lordship. Therefore, the principle of res judicata cannot be invoked in the present case, your lordship.
These parties are the same. Okay, please go ahead with your next
Yes.
issue. You have very limited time. We'll ask questions later. Go on.
Much obliged, your lordship. Your lordship, the second issue deals with whether or not mentioning the date of default is mandatory in applications under IBC. It is most reverently submitted before this honorable court that the mentioning of default date is mandatory in the applications under IBC 2016. The council will be dealing this under two phases. One which explains the statutory mandate, and the other phase deals with the points which to be determined based on the default date. Moving on to the first phase, that is the mandatory statutory framework. Under Section 7, Clause 1, a financial creditor may file an application before the adjudicating authority when a default has occurred. Further, Rule 4, Clause 1 of the Insolvency and Bankruptcy Rules 2016 mandates that such an application must include the date of default and amount in default. The mentioning of date of default in Section 7 application is mandatory as it determines jurisdiction, limitation, and applicability of statutory bars, if any, such as Section 10 capital A. Further, failure to specify the date of default affects limitation computation and renders the application defective. In the very case, keeping these provisions in mind, the ABC Bank has mentioned the date of default in both the applications complying the statutory framework. Your Lordship, in addition to this, the Council would like to bring attention to the case of M. Suresh Kumar Reddy versus Canara Bank and others, which has been displayed, where the Supreme Court observed that once NCLT is satisfied that the default has occurred, there is hardly a discretion left with NCLT to refuse admission of the application under Section 7. Thus, even the non payment of a part of debt when it becomes due and payable will amount to default on the part of a corporate debtor. In such a case, an order of admission under the Section 7 of the IBC must be followed. Hence, the mentioning of date of default is mandatory, but more emphasis should be given to the validity and determination of debt in the case of rejecting an application, your lordship. Moving on to the second phase, that is the determination of limitation period based on the date of default. The date of default is crucial for determining whether the application falls within 3-year limitation period under Article 137 of the Limitation Act 1963. Without it, the adjudicating authority cannot assess the application's maintainability. Furthermore, under Section 18 of Limitation Act, a fresh limitation period begins from the date a written acknowledgement of debt or liability is made before expiry of the original period.
Council, your time is up and you're not very audible also.
The limitation period stands extended as XYZ Limited sought credit restructuring and multiple one-time settlement proposals.
Council, your time is up.
The last contention, that is the applicability of statutory bars such as Section 10 capital D. The disclosure of the date of default is mandatory to determine whether an application is barred from initiating CIRP. In this case, the ABC bank duly specified the default dates in both the applications before the adjudicating
Um,
authority,
Court Master,
enabling assessment of
Yes, ma'am.
her time is up.
paper.
No,
The first
counsel's time.
application was dismissed.
The next counsel may proceed with the same argument if
Prevailed
required.
procedural bar, not on merits, and a subsequent application is unaffected by Section 10 capital A of the IBC, thereby complying with this. Your Lordship, now, am I audible now, Your Lordship?
Counsel, your
Hello.
connection seems to be a little unstable. Your time is up. Your co-counsel may continue your argument if required.
Greetings, Your Ladyship. Is the council audible and visible?
Hello.
Yes.
Much obliged, Your Ladyship. The council seeks permission to continue with issue 3.
With issue 3, you won't finish issue 2?
Uh, Your Lordship, the council is not clear with where my co-counsel left because of all the network issues.
Okay, issue 3. So,
Much
but
obliged, Your
issue
Ladyship.
3, however, issue 2, however, talks about your maintainability in all essences. So, try and cover that as well.
Much obliged, Your Ladyship. In issue 2, we wanted to state that the date of default is mandatory because of two reasons. Firstly, being the statutory requirement as provided under the various laws. Now we have section 2. Yeah, we have section. Uh, just give me a moment. We have section 7 in which the application in section 7 application it is mandatory for us to mention the date of default. Then we have rule 4 clause 1 of the insolvency and bankruptcy application to adjudicating authority rules of 2016, and as well as the regulation 2D of the IBBI CIRP regulations. Also, the next contention that we wanted to put forward was that the date of default is important for the determination of the limitation period, as well as to check whether the application of any statutory bars is applicable for the present matter. So that was what we wanted to argue.
Okay.
If your lordship permits, can I move on to the third issue?
Yes.
Much obliged, Your Ladyship. So the third issue is whether or not the date of default changes based on facts and circumstances, or is it to be taken as the date of NPA in all bank matters? So for this, the council most respectfully submits that the date of default is determined based on facts and circumstances, and this will be substantiated under two heads of argument. The first one being the council would like to bring into light the chronological events of the chronological
Not
order of the
required.
event.
Not
Much
required.
obliged, Your Ladyship. Um, so the council would like to point out that in the present case, multiple valid dates of default can be legally recognizable. To support this, the council would like to give emphasis to the case of Pratip Madhukar More versus Central Bank of India, in which the NCLAT has held that the one-time restructuring agreement would set the new default date. In other words, the OTR and the OTS agreement that are entered into between the bank and the corporate debtor is a binding legal contract.
So therefore, any default under this agreement would constitute a fresh event of default for the purpose of Section 7. Here, the council would also like to place reliance on the case of Reliance Asset Reconstruction Company Limited versus Hotel Puja International, in which it was held that the acknowledgement must be done prior to the expiry of 3 years of limitation via OTS, and the same judicial decision can be applied here. The council would like to further point out that the COVID period default under the OTS was a fresh default, but Section 10A only submitted the remedy of filing under the section, but it did not wipe out either the underlying debt or the earlier continuing default that started from the year 2014. When the second application was filed in 2024, the bank was entitled to rely on the original continuing default date supported and kept alive by the repeated OTS acknowledgements. Your Ladyship, it is important to note here that the default during the COVID period was not the first instance of default. It was a continuing default which started on the date of the NPA. The council would like to move on to the
And
second
why was
limb of the
your first application, you made it you made the date of default in COVID. Now why are you bringing it into different fold? It looks like forum
argument.
shopping, na?
Much obliged, Your Lordship. The council would like to differ from that point. It is not forum shopping. The As the first application was barred by the Section 10A, uh, the second application, as already argued by my co-counsel, the the principle of res judicata is not exactly applicable here, because both the first application and the second application are on different cause of action, because the second application is claiming the actual outstanding loan amount, while the first application was claiming for the default of the OTS amount only. Whereas, so the OTS amount is usually a compromised amount which is not equal to the outstanding loan amount. So that is why we are arguing that these are two separate cause of action. So as the first cause of action was has been barred by Section 10A, this cause of action is not barred because the default is still being kept alive by all the acknowledgements throughout the years. If you okay, much obliged, Your Ladyship. So uh, the next contention is that the NPA date is considered as a prudential measure, although it is not a mandatory requirement. So, for this, the council would like to cite the case of Milind Kashiram Jadhav versus State Bank of India, in which it was observed that the reliance on the date of the NPA declaration by the adjudicating authority instead of the date of recall was correct and was also supported by the judicial precedents and facts in the particular case. So, here, in the present case, the council would like to submit that while the classification of the account um, as the NPA date it is not a mandatory legal precondition for all the banking matters, that it should be regarded as a default date unconditionally. But this has also been reiterated in the landmark case of Lakshmi Pat Surana versus Union Bank of India in paragraph 37, as is being presented here.
Hmm.
The council would also like to place reliance on the case of BK Educational Services Private Limited versus Parag Gupta and Associates, in which the Supreme Court has acknowledged that normally the date of default is a date when the account of the borrower has been declared as the NPA. Your Ladyship, the ultimate argument that the council submits is that the date of default in a Section 7 application is ascertained based on the facts and circumstances. And in our case, the facts support the date of NPA to be considered as a date of default. If your lordship permits, may I move on to the fourth issue?
Can you draw parallels to that case law and your facts?
The BK Educational Services, your lordship.
Yes. Hmm. How that is applicable to you directly?
Your lordship, the court had um, observed that normally the date of default will be the date of the NPA. So for the present issue, they are asking whether the date of NPA is always the date of default. For that, the council is arguing that no. It is not always the date of NPA, but usually the date of NPA is relied upon. Much obliged, your ladyship. Uh, may I move on to the fourth issue?
How are you trying to make that relevant to your case? The date of default and the date of NPA being the same, how are you trying to make it relevant to your case here?
The council is arguing that the appellant has acted correctly by relying by mentioning the date of NPA as the date of default in the second application.
Okay.
Much obliged, your ladyship. So the fourth issue is whether or not a case can be admitted if the default has occurred and the application is within limitation despite an error in the date of default. Your ladyship, the council would like to begin by stating that the procedural law is not to be a tyrant but a servant, not an obstruction but an aid to justice. The council humbly submits that the case can be admitted on the basis of three grounds. Firstly, being a statutory
Sorry.
requirement.
Um,
Ladyship, in this honorable apex court, in the case of Innoventive Industries Limited versus ICICI Bank, in paragraph 28, as is being presented, it has laid down the guiding principles to admit or reject an application filed under Section 7 of the IBC. So the adjudicating authority is to only determine whether a default has occurred and whether the debt was due and remained unpaid. Then the application must be admitted unless it is incomplete. So the twin requirements are the existence of a debt and the occurrence of a default. Your ladyship, in the present case, neither the debt nor the default has been disputed. In fact, both the debt and the default are conclusive facts which have having been repeatedly acknowledged by the corporate debtor through a series of one-time settlement proposals and correspondence over the years. The council would the second ground of my argument is that substantive law is over procedure. A procedural law is always subservient to the substantive law. So nothing can be taken away by the nothing can be taken away by the procedural law. What is given by the substantive law, as enshrined in the case of Sayat Bakar El Idros versus Abdul Habib Hassan. This court has also held in Surendra Trading Company versus Jagilal Kamlapat Jute Mills Company Limited in paragraph 43, as is being displayed, that the mandate of the section 7 clause 5 is procedural in nature and it is a tool of aid in expeditious dispensation of justice and is directory. The council would also like to point out that the NCLAT has held in the case of Mr. Manmohan Singh Jain versus MS State Bank of India and another, that even the non-mentioning of the date of the default is not fatal to the application and the application cannot be rejected on the sole ground of a technical impediment, your ladyship. So, hence, an application under Section 7 should not be refused by the adjudicating authority merely on procedural grounds in order to ensure that the financial creditor is able to realize his debt and thus fulfilling the objective of the IBC. Being this stated, the council would like to move on to my third ground of contention that such procedural errors can be rectified by the principle of curable defect. Your ladyship, in the case of Uday Shankar Triyar versus Ram Kalivar Prasad Singh, the Supreme Court held that the procedural defects or irregularities which are curable should not be allowed to defeat the substantive rights or to cause injustice, your ladyship. To answer the issue at hand, the principle of curable defect would permit an applicant to correct a procedural error or an error in the default date through an amendment application instead of facing summary dismissal. The council would further wants to submit that there is no bar in the law to the amendment of the pleadings in an application. The same has
Your
also been
curable defect
reaffirmed.
that you're talking about, counsel, how is this a curable defect when it is the main crux of the cause of action? You are not clarifying whether the cause of action has occurred on 2014 or in 2022. That itself is such a substantive question. How are you trying to bring it into the fold of curable defect?
Much obliged, your ladyship. The why the council brought this is because it was solely to address the question at hand. Because the issue was whether whether an application could be admitted if there was an error in the date of default. So just solely to answer this question, the council is just submitting that if at all there is an error in the date of default, then then an amendment could be brought in using the principle of curable defect. But in the present case, what the council is submitting is that there is no error in the date of default, as there is as it was already argued by my co-counsel, um, because both the applications are of different cause of action. We are not stating that there is an error in the second application in relation to the date in the date of default. I brought, the principle of curable defect was brought in just to address the fourth issue. But yeah because of this is a completely different cause of action, we are stating that there is no error in the date of default, so the application can be admitted.
Your cause of action, I don't find as maintainable. So if you can convince me on something of that, we can consider.
um, the council has no other points to convince.
Okay. How is this maintainable before this court?
Uh, Firstly, the appellant is entitled to go for an appeal under section 62 of the IBC, which allows an appellant to appeal from an order of the NCLAT.
Mm.
So yes, Your Lordship.
So you're saying that NCLAT, you have an appeal that lies under
Yes,
section
Your Lordship.
62. Okay.
Yes, Your Lordship.
All okay.
So therefore, it is most humbly submitted that uh, it yeah that this appeal has been sought this application has been sought only in the bona fide and legitimate interest of the financial creditor, solely to secure the repayment of the outstanding loan amount. So
Mm.
if Your Lordship is satisfied, may I move on to the prayer?
Okay.
Much
And then
obliged,
wrap
Your
it up.
Lordship.
Your time is up.
Much obliged, Your Lordship. Wherefore, in the lights of the issues raised, arguments advanced, and authorities cited in the Republic of Indigo, the appellant humbly prays before this honorable court to declare the second application as maintainable and to permit the initiation of CIRP and pass any other order as this honorable court may deem fit and proper in the interest of equity, justice, and good conscience. And for this act of kindness and justice, the appellant and its counsel shall be duty bound and forever pray. With this, the council would like to rest the case. It has been a great honor presenting our case before this honorable court. Thank you.
Okay. Snigdha, just pause for 2 minutes, okay?
Okay.
Greetings and good morning. I'm the counsel on behalf of the respondent in matter of ABC Bank versus XYZ Private Limited. The
Mm.
counsel seeks permission to address the bench individually as your ladyship.
Mm.
Much obliged, your ladyship. If your ladyship is well versed with the facts of the case, the counsel seeks permission to proceed to the submissions. If not, for the convenience of the bench, the counsel shall present a timeline for the statement of facts.
Not required. Please go ahead with your
Much
arguments.
obliged, your lordship. If your lordships, before proceeding to the arguments under the issue, the council seeks to explain the role division between the council and co-council. The council would present arguments on issues 1 and 4, while the co-council would present contentions under issues 2 and 3 and the respondent's prayer. If your
Mm.
lordships are satisfied with the rule division, the council seeks permission to present the submissions
Go
under
ahead.
this manner. Much obliged, your lordship. Your lordships, your ladyship, the issue 1 pertains to the question of whether The second application under Section 7 of the IBC is barred by the law. The council humbly submits that the second application is clearly barred by the law. The council shall establish that the application is not maintainable in a two-pronged manner. My first prong pertains to that the principle of res judicata is clearly applicable in this case, and therefore the application is barred. The council shall rely on the same statute which was raised by the appellant's counsel, which is Section 11 of the Civil Procedure Code. The rule of res judicata, as provided under Section 11 of the Civil Procedure Code, bars the same parties from contending the same issue once and again after a competent court has already decided. Your Lordships, if you may refer to para 3 of the respondent's memo. Uh,
1 second.
yes, Your Lordship.
Respondent, para 3, can you tell me the page number, please?
Yes, Your Lordship. Page number 10, para 3, Your Lordship.
Page number 10, para 3. In the financial creditors.
Yes, Your
First
Lordship.
section. Yeah.
Versus Vijay Nirman and Shiodan Singh versus Daryan Kumar, both the judgments retrace the same argument which was advanced by me, that once a competent court has decided on a matter and its decision becomes final, the same issue cannot be raised again. Further, Your Lordships, on applying the submissions in the present matter, it can be understood that the present application is barred by the doctrine of res judicata, as the decision of the NCLT and NCLAT under Section 10A is in the first case clearly said the supposed default happened during the suspended period. This decision by the NCLT was a final ruling as to whether NCLT and NCLAT is a final ruling whether the NCLT had the right to act. And so it stops another case on the same depth from being heard again. It is pertinent to note that, Your Ladyship, the earlier application with date of default as 1/5/2020, which deals with the same depth, was also dismissed on merits. It is given in the proposition para 9.
Para 9.
Of the proposition, Your Lordship. Now moving on to now moving on to my second prong of my contention, Your Ladyship. It is my second prong is that the financial creditor cannot unilaterally change the date of default as an attempt to circumvent a statutory bar or limitation. Your Ladyship, I wish to draw your attention to para 8 of the respondent's memo, where the Amravati Bank.
You can share your screen for respond.
Yes, researcher, may you share the respondent's memo here?
Are you finding it hard to share it? I'll open mine.
Much obliged, Your Lordship. No, Your
Para?
Lordship. Your Lordship. Para 8. Your Lordship, I'm finding it hard.
Okay. Page 11, para 8.
Yes, Your Lordship. Page 11, para 8, Your Lordship.
The Honorable Supreme Court in judgment of Gaurav something, Hargovind Bhai Dave and etc. What about this?
Sorry, Your Lordship. Your Lordship, just a minute, Your Lordship. Para 8, Your Lordship, with respect to Canara Bank. Just a moment, Your Lordship. Yeah. Para 8 of the judgment, Your Lord. Yeah, para 8 of the respondent's memo, Your Lordship, where in the judgment of sorry, Your Lordship.
Para 7.
Yeah, para 6, Your Lordship, in the judgment of Rolta Private Limited versus Varingan Cloud, where it was unequivocally held that the financial creditor in this matter, ABC Bank, cannot shift the data default date subsequently, and that such a change amounts to impermissible enhancements of the pleadings. Hence, it makes the application filed at a later stage defective and untenable in the date of default change, Your Lordship.
If the date of default in that specific case was changed, because see, amending your prayer is a different story, and here we are trying to bring a total new cause of action. The appellant, as they've argued, they're saying that 2014 and 2022 are two separate causes of action.
However,
I'm sorry. Hmm.
yes, the appellant. However, they haven't clearly proved how it becomes a different cause of action, because even though they presented that it's on different dates, the issue at hand is of 500 crores, and the co-counsel did not have any points at the conclusion to prove the convince it's a
Your
different cause of action, Your
counsel do
Lordship.
not attack on their whatever iteration it is. End of the day, the court, you are addressing me. I am asking you, why are you telling me that 2014 and 2022 are the same causes of action? 2022 is arising out of a specific OTS scheme. 2014 is out of a different specific OTS
Yes, Your
scheme.
Lordship. For the
How
very
then?
reason, yes, Your Lordship, for the very reason that the debt, both the cases, the debt is of the same, Your Ladyship, which is of 500 crore.
Hmm.
Uh, if Your Lordship is convinced, the council seeks permission to move
No,
on
you
with.
have not distinguished how these are not two separate causes of action. The limitation, condonation of limitation, and all of that is up to we have the judicial discretion to condone delay if there is legitimate reason. However, you need to show me why this is not maintainable as a case, because very clearly 2014 and 2022 are two separate causes of action. They arise out of two separate OTS schemes.
Your Ladyship, the application filed under 1222 came under the default which occurred on 1/5/2020, Your Lordship, which was dismissed by the NCLT and NCLAT. Further, uh, the second application came under the date of default being 1/4/2014, which is the date of NPA, Your Lordship.
Okay, go on.
Much obliged, Your Lordship. Uh, uh, in the uh, in the present matter, Your Lordship, the date of default has been changed only to get rid of the statutory bars under Section 10A of the Code, and the tribunal had rejected the first application on that ground, admitting the application would defeat the very legislative purpose of Section 10A, indirectly allowing going around the statutory ban. Thus, Your Lordship, on combining the two prongs of the uh, submissions, it can be clearly understood that the present application is barred. If your lordships are convinced under the arguments under the first issue, and if there are no further preliminary questions, the council seeks permission to make submissions under the fourth issue.
Not convinced, but go on.
Much obliged, your lordship. Your lordship, issue 4 pertains to the question of whether an application that has an error in the date of default uh, can be admitted, given that the default has occurred and the application is within limitation. Your lordship, the council's submission is that the case cannot be admitted in the event where there is an error in the date of default. The council shall establish why the case is not to be admitted in a two-pronged manner. The council's first prong is that your ladyship, a defect in the date of default is not a minor default; it's a fundamental defect. The council shall establish by relying on three judgments, your lordship. First, Jignesha versus Union of India, where it was held that strict interpretation of procedural errors is is to be taken in the matters of the IBC.
Mm.
Further, the next judgment being Babilal Gurjar versus Veer Gurjar Aluminium Industries Privately Limited, where the same judgment and the same ratio of Jignesha versus Union of India was again held. And third one being the decision of the principal bench of NCLAT in the judgment of Haridas Gautam Kumar Dev versus Indian Transformers Company Limited and others, where again the same thing, That is, strict interpretation of procedural errors should be taken in the matters of IBC. This category of judgments, Your Lordship, clearly imply that date of default is a fundamental aspect, and therefore a defect in it would make it a fundamental defect. Moving on to my second prompt of prompt of my contentions, Your Ladyship, is that IBC is to operate in a time-bound manner. The council submits that the nature of IBC is time-bound. The objective of the IBC is reorganization and resolution of insolvency of corporate debtor as given in the proposition para 8, Your Ladyship.
Uh,
This time-bound operation calls for the strict interpretation for date of default.
mm,
Thus, uh, uh, this has been the nature of the objective, as in the nature of IBC being a time bound, is given under the judgment of Swiss Ribbons versus Union of India, which is a landmark judgment given by Justice Nariman and Naveen Sinha, Ladyship.
mm.
Further, the city assembly submitted that under all the conventions, the city in the date of default is an utter disregard for this very time-bound nature of the code, rendering it meaningless. A case cannot be admitted if there exists an error in the date of default. Admission of a case with an error of default is detrimental to statutory safeguards and legal certainty. Must oblige your leadership for the patient hearing. If your leadership are convinced of the submissions under issues 1 and 4, the council wishes to call upon my co-counsel to make submissions under 2 and 3, your ladyship.
Okay, 2 and 3 can go ahead.
Much obliged, your ladyship. It was an honor arguing before your ladyship.
Greetings to the honorable bench. Now that my co-counsel has dealt with issues 1 and 4, the council seeks permission to address the issue 2 and 3.
Hmm.
Much obliged, Your Lordship. With respect to issue 2, whether or not it is mandatory to mention the date of default in application of IBC, it is humbly submitted before this court that default mentioning of the date of default is a mandatory requirement, statutory requirement, and it is not merely a procedural formality.
Hmm.
As it attracts section 7, which
Hmm.
gives us 2 requirements.
Hmm.
First, the existence of a debt and its subsequent default.
Hmm.
It directly determines limitation and maintainability of the application. The appellant has, in clear violation of this mandate, attempted to shift the date of default multiple times in the first application filed on 1/2/2022. They themselves asserted 1/5/2020 as the default date, arising from the cancellation of OTS on 1/5/2020. This fell squarely within the statutory suspension period under Section 10A and was therefore rejected by both the NCLT and NCLT. Now, in the second application filed on 1/1/2024, the appellant has attempted to drastically alter the date of default to 1/4/2014 and the date of NPA classification. This conduct has also been condemned by the NCLT in its judgment in the case of Asset Reconstruction Company Limited versus Manyata Developers Private Limited, where the tribunal held that the date of default is a compulsory concept and changing it creates a defective application attracting Section 7, Clause 5, Clause B.
Hmm.
If your lordship is satisfied with the arguments pertaining to issue 2, may I please proceed with issue 3?
Do you not have any citations to substantiate this point?
Your lordship, as I cited the case of Asset Reconstruction Company versus Manyata Developers Private Limited, where the NCLT condemned this conduct of changing the date of default and mentioned it as a compulsory concept, and changing it creates a defective application attracting the Section 7(5) Clause B.
But here they have not changed the date in a very during the process of admission, right? They have only changed. This is a new, fresh cause of action that they're trying to bring about. There are two OTS schemes, from what I understand. One that was from the NP from from NPA from 2014 was one thing, and the other one was in 2020 or 2022. So those are two separate causes of action. Then why are you saying that they're only changing the default here? They are bringing about the whole thing, the whole entire thing at once.
Yes, Your Lordship.
So if that ARC case law that you are talking about, it would become relevant if it was during the course of this case where they instituted it as stating as the date of default being 2022 and subsequently changing it to 2014, then it would be applicable. However, you have not convinced me otherwise. Can you please elaborate?
Yes, Your Lordship. Your Lordship, in this case, first application was filed when the OTS cancellation was done, and this was mentioned as the date of default. But when this OTS cancellation, this date of default was squarely within the statutory bar. To circumvent the statutory bar, they again mentioned it as the 2014 default. So
Yes,
this is
sir,
just
but
done to
you do realize that we are now not in the NCLT aspect where technicalities and procedural law will sustain. Here we are on the question of substantive law. When that is the issue, we decide whether there has been a wrong that has been done or not, and based on that, we will go ahead. We do have those judicial discretions to go beyond some aspects, right?
Yes,
So if we condone the delay of filing uh, at such a post date date, then why is 2014 not admissible at this point, maintainable at this point?
because the lordship, it is done to circumvent the statutory bar and it is against the legislative intent of the section 10A, and its
10A
purpose
is a 10A has a moratorium. Sorry, please continue.
is, and its legislative intent is to protect the corporate debtors from financial distress.
10A has limited scope.
Yes.
Is that not right? Because 10A, from what I understand, has limited scope. It is only pertaining to those transactions that have happened in during the period of COVID. So when that is the case, this has happened long before COVID caused issues have come up. Then why is this not maintainable? None of you have been successful. Okay, go on.
Mr. Lordship.
Hmm.
Your Lordship, may I please proceed with issue 3 if that will
Yes.
answer your question.
Huh.
Yes, thank you. Issue 3 pertains with whether or not the date of default changes based on facts or circumstances, or is
Huh.
it to be taken the date of NPA in all bank matters?
Hmm.
With respect to issue 3, respondent humbly submits that the date of NPA does not automatically become the date of default, and this has been affirmed in the case of Lakshmi Pat Surana versus Union Bank of India, where it was clarified that the default is a singular crystallized event and not interchangeable with prudential banking classification.
Hmm.
Appellant's reliance on 2014 NPA date is therefore untenable.
Hmm.
Moreover, in Gaurav Hargovind Bhai Dev versus Asset Reconstruction Company, it was held by the Honorable Court that the NPA triggers limitation cannot be endlessly adjusted by later acknowledgement. Here, the appellant is not merely clarifying but manipulating dates, first choosing 2020 to escape limitation, then choosing
Hmm.
2014 to escape Section 10A. Such temporal
Hmm.
shifting is precisely the kind of abuse of the process, and it seeks to prevent uh, and the factual record, including continuous structuring of the letter and OTS request from 2014 to 2022, demonstrates ongoing negotiation rather than a new default. Therefore, the respondent respectfully submit that mentioning of date of default is mandatory and it cannot be changed on the basis of facts and circumstances.
Hmm.
Your Lordship, if you have any question, if you don't have any question, then I may please proceed with the prayer.
Go ahead with the prayer.
Much obliged, Your Lordship. Your Lordship, the respondent's prayer on on the basis of four issues is twofold. One, to dismiss the present appeal, and second, to uphold the order of NCLT and NCLT.
All right.
Much obliged, Your Lordship. It was an honor arguing before this court. I may rest my case now. Thank you.
Okay, does the counsel for appellant have any rebuttals?
Yes, your ladyship.
Hmm.
Your ladyship, the council would wants to ask that the respondent has submitted
Yeah.
that that the date of default is not the NPA, nor
Hmm.
is it being determined by the facts and circumstances. Then
Hmm.
how does the respondent say that date of NPA is determined? This is one question that we would like to ask.
Okay. Whom are you asking this question? Respondent will only give whatever iteration they have. You ask, so as a practice now, you'll all come to law school or out of law school, and if you come to litigation, no, you never question the judge. You don't address the question to the judge. You address it as posing a question to myself, and then highlight whatever point it is. Okay, so that is one thing. Um, and when you're arguing the matter, you're addressing that bench, you're not addressing the other side. At this point, it does feel like a competition. This is for all of you, all however many of you are there. Um, all of you just keep in mind that you're not addressing each other, you're addressing the court. So that should be the way that you conduct yourself. But yeah, your rebuttal question, yeah, they have not answered as to the maintainability. All right, so rebuttals is usually only for the appellants and not, or for the petitioner or appellant, and not for the um, respondents. So if you guys are done, we can wrap it up.